Hello, everyone. Welcome to this month's webinar, Leaky Basements, Clauses, and to disclose or not to disclose. Thank you very much for joining me. I'm Geoff Rabideau of Rabideau Law, the principal lawyer. I trust you all know me. Today, what we'll be covering is latent defects versus patent defects. We're going to be looking at Clause 26, the agreement in writing clause, as well as case law. We're going to be looking at the duties and duties of disclosure, and that's in respect to the seller and the selling agent, as well as we're going to look at protective clauses for buyers. And lastly, we're going to look at what's RECO's position on the duty to disclose. And obviously, we'll also talk about, as always, my favorite best practices. So starting off with here, we're talking about patent defects. And so we see the definition of a patent defect is a defect that a buyer or the buyer's home inspector can detect through reasonable observation and inquiry. Visible, obvious, discoverable on an ordinary walkthrough of the house. An example we see would be a sloped or uneven floor, efflorescence or visible cracks in a foundation wall, as we see here in the picture. Otherwise, it could be stained or damaged ceiling, walls, or flooring, and also peeling paint or warped baseboards. The rule, as I trust you all know, is caveat emptor, which is buyer beware. A seller has no duty to disclose or to point out what a reasonable inspection would find. One caution, however, though, a seller who tries to hide a patent defect, either by moving furniture over a stain or timing a showing so it skips an obvious problem, can lose the protection of buyer beware entirely. This is all in RECO Bulletin 7.4, which says that a patent defect should not be actively concealed, or a buyer beware may no longer apply. And obviously, the key takeaway here is that visible problems are the buyers to find. The seller's only job is not to hide them. Next, we're going to talk about a latent defect. Now, a latent defect is a defect that would make a property unfit for habitation. It is dangerous or potentially dangerous and is not apparent to someone exercising reasonable care on inspection. And that's coming from the RECO Bulletin 7.4. The legal nuance is unfit for habitation is not the same as I can't live there, right? Courts weigh factors. So when a court is looking at something as unfit for habitation, it weighs several factors in determining whether or not something is unfit for habitation. It's not strictly based on the plain English understanding of I can't live there. And examples of latent defects would be a foundation crack behind a finished drywall, chronic seasonal seepage covered by fresh paint, a prior flood fixed and never mentioned, and mold growing behind a recently renovated wall. None of these are visible on a normal walkthrough. That is exactly what makes them latent, and exactly why disclosure is the only protection a buyer has, right? So in these instances, a buyer would not be able to know. But the seller, provided the seller knows about these or has knowledge of them, then the key takeaway is that the seller has to disclose. And therefore, a leaky basement hidden behind drywall or paint is the textbook latent defect. I can give you an example of this one. I had a client who purchased a property and he started renovating in the basement. And his goal was to take out one of the walls because he didn't like it. He wanted to open up his basement. When he took down the drywall, he found a whole wall behind that drywall of black mold. So what had happened was the seller had just put up new drywall over that wall of black mold, painted, mudded, painted, sanded, everything, just to sell the property. And the reason why we were able to tell that when they put it up is because the drywall was date stamped. So on the back of the drywall, there was actually a date it was created and made, and it was obviously very recent. And so therefore we were able to pinpoint that as a latent defect and the seller was trying to conceal it. Now, there are two exceptions to caveat emptor, buyer beware. It's very important to know that not all provinces or all places run on buyer beware, but Ontario still does. Ontario still goes by the understanding that it is the buyer's duty to find these problems, so buyer beware. But the courts do carve out two narrow paths or exceptions. The first is the known dangerous latent defect. That's where, let's say, the seller knows about this defect, and therefore the seller knows or willfully is blind to the latent defect and makes the property dangerous or unfit for habitation. So the idea is this defect is known, but the seller is not going to disclose it. It's dangerous, it's black mold or something of that nature. Let's say in the attic, the seller knows about it, but they're not going to disclose it. The next one is active concealment or misrepresentation. And this is where the seller or the agent actively hides the defect or makes a representation about it recklessly or dishonestly, that in the intent to misrepresent the property, in the intent to induce someone to enter into the purchase of the property. Now that is fraud. That is outright fraud. And that example I talked about the seller who had covered over one wall with drywall, that was fraud, right? And that was actionable. My clients actually did sue them for that. Now the key takeaway from this slide is that outside these two paths, caveat emptor wins. Buyer beware wins. So no matter how frustrating that feels to a buyer, it's very important that the buyer does their due diligence, gets a home inspection, and is very thorough on their inspection of the property. So when does silence become fraud? The legal test for concealment means that an act done with the intent to hide from view a defect the seller is aware of or willfully be blind to. So concealment means that the seller actually went through the process of trying to hide it. Now the courts have gone even further than the legal definition, and the courts have even considered concealment without an intent to deceive. So it doesn't matter whether or not the seller intended to deceive, it's whether or not they concealed. And so for a good example, and I trust all you realtors have seen this before, boxes stacked together. So very often boxes will be stacked together in the basement, and then post-closing, you could find out that there was some damage behind that wall or near that area. And that is an act of concealment. It may not have been done with the intent to deceive, but it still was an act of concealment, okay? And that still would be treated as fraud because it is a misrepresentation of the property. And so why does it matter? Well, fraud unwinds the protection a seller usually relies upon, which includes the entire agreement clause, clause 26, as is, where is sales, and any disclaimer language in the seller property information statement. So none of those would protect a seller who commits fraud. And so therefore, it is very important. The key takeaway here is that the intent to deceive helps prove fraud, but it is not always required. The act of hiding can be enough. The leaky basement playbook. So let's talk about, obviously, one of the biggest concerns with water infiltration, water seepage, is leaky basements, right? That's the one thing I've noticed when I'm doing a lot of deals this year, and actually talking to you guys. After my last webinar, I went and I asked you a question, what do you want to talk about? And like the majority of you had mentioned water infiltration, leaky basements. So thank you. That's why I created this topic in this presentation. So what we talk about here is, here's the playbook for leaky basement. We have seasonal seepage, there's the cover up, there's the dry season sale, and then the reveal after closing by the new purchaser. That's the standard playbook, right? So the key takeaway here is that courts will ask two questions. Did the seller know? And did the seller hide it? Timing and bad luck are not a defense. It has to be, did the seller know, or were they willfully blind to it? Right? And if they were, that's a yes. Then the next question becomes, did the seller hide it? And that's the test the courts will go through. Did the seller know, or were they willfully blind? Yes. Did the seller conceal or hide? Yes. Guilty. Now, we did talk earlier about there are certain clauses in the agreement of purchase and sale that, and I talked about a slide previously, I talked about, hey, you could do you could put the entire agreement clause 26 in the agreement purchase and sale might provide some protection. We also did talk about there's the as is, where is, and any limiting information or wording in the SPIS. Now, as I mentioned in the previous slide, any of these, if there's fraud involved, fraud will defeat any of these. The entire agreement clause, as you guys know from my previous presentation, is that anything that is outside of the contract, outside of the agreement of purchase and sale, does not affect the agreement of purchase and sale. So remember how we talked about if someone had represented on the MLS listing that it was a brand new roof, but after closing the buyer found out it was not a brand new roof? Well, hey, that would not follow into the agreement of purchase and sale, provided it was not done with the intent to deceive. Maybe it was just a mistake, right? But what this says that is the entire agreement clause, clause 26, does not defeat fraud. So if in the event there's fraud, you cannot rely on the entire agreement clause, right? So that's where, let's say in the MLS listing, it says, you know, great finished basement, no water infiltration, no problems. Or let's say the seller just, you know, hides it and conceals it, and the buyer, you know, doesn't know about that, comes in, there's latent defect. None of that will protect here. The entire agreement clause won't protect and shield that from coming in, right? That's, like I say, that's the entire agreement clause. Clause 26 is the one that all of us lawyers love to use the most, saying, hey, it doesn't form part of the written contract, therefore it can't come in. Well, this clause doesn't work in that case because this is fraud, concealing, okay? So key takeaway here, confirm the exact clause numbering against the current OREA form in use. Numbering shifts between form revisions, right? I call it clause 26. Maybe some other forms would call it a different number, but the OREA form 100 is clause 26. Now, the important part is there is a gap, right? There's the gap between the printed OREA form has no standard clause addressing physical condition or latent defects at all. Only a narrow fixtures and chattels good working order warranty and the title clause. So that's the other side. There's a gap here. There's no clause in the agreement of purchase and sale that protects against water infiltration. That's why it's on you guys to put a clause in your agreement of purchase and sale. Now, before we get to the clauses, I'm going to show you some clauses. I want to talk about the case law and what the case law has said about certain clauses. Next, we have this case. I'm not even going to try and pronounce it. I just know it's Beauchamp versus Beauchamp. And it was a 2013 case, Ontario Superior Court. And so what happens, there was a seller property information, SPIS, involved. And the SPIS had said there was no flooding, no moisture problems on the property. 9 days before closing, after the buyers had entered into the agreement of purchase and sale and waived their conditions, so the agreement of purchase and sale was, at that time was firm, water entered the basement. The sellers dried it out and said nothing to the buyers. They didn't disclose it. The deal closed, and then it flooded again 3 weeks after closing. The courts held that the pre-closing flood was an important change, a material change to the SPIS, and that the sellers had an ongoing duty to disclose it before closing. And the entire agreement clause, which says clause 26 doesn't form part of the agreement per sale, did not excuse the silence. So therefore, damages of $25,000 were awarded. So key takeaway here is if a SPIS was given, the seller's duty does not end at the signing of the SPIS or signing the agreement per sale. Their duty continues up until closing. Okay. Now we have a more recent case. This is a brand new case, just came out January of this year. And so what this case was and I'm going to explain the case to you because it's pretty interesting. A North Bay buyer a North Bay buyer was buying a property, and the inspection flagged only minor issues, home inspection. After closing, the water surfaced through the basement floor, noticeably where a piano was set on it. So a heavy piano, water was coming through the floor under that piano. Foundation cracking, long-standing moisture, and hidden mold, and a defective deck were found, all right? With repairs exceeding $119,000. The seller had done drywall repairs in the rec room where the piano was sitting, and that was done before the listing, and the court found he would have seen the water damage before the work, right? The holding of the court was 2 points. The first, a clean inspection is not a shield. So a home inspection does not vitiate or defeat the responsibilities of the seller to disclose or the duty not to conceal. Okay, that's very important. And I get that argument all the time with other lawyers. The lawyers say, well, you know what? Your purchaser had a home inspection, so therefore they don't have any case. And I'm like, no. you gave a warranty, there's a condition or something of that nature in the agreement of purchase and sale. So a home inspection doesn't defeat the written terms in the agreement of purchase and sale, which I hope you guys all know that it doesn't, but a lot of lawyers like to argue that. And the next one is there was a survival, there was a representation, a clause in the agreement of purchase and sale. It was a warranty, and the agreement of purchase and sale warranted that no damage since the buyer's last inspection had occurred, and it indicated that this clause, this warranty, did not merge on closing. So therefore, it survived closing. So it's very important for you to know, with an agreement of purchase and sale, all the conditions in the agreement of purchase and sale end on the day of closing. So let's say all chattels and fixtures shall be in good working order, ends on the day of closing. The only way those chattels or fixtures could survive closing would be if there was an addition to that clause saying that the clause does not merge on closing. Okay? And so the court treated this case that it was an independent additional basis for liability, and on top of that, negligent misrepresentation. So in this case, the buyer was awarded $119,000 because the seller did not disclose. Now here, there was no SPIS, all right? There's no seller property information statement. It was strictly the fact that the seller should have known about it or did know about it, or they're willfully blind to it, because it indicated that the seller had conducted some work renovating in the basement. They put up new drywall on a wall, so therefore they should have recognized when they had the baseboards off or something like that nature, they should have recognized the water damage coming into the property, right? So it's important to know that a survival clause isn't boilerplate window dressing, okay? In this case, it's part of what made the seller liable. So therefore, you have to remember the survival clause, it was what matters in order to protect your buyers. Now, before we go to the actual condition clauses I want to talk to you about, we're going to talk about how long does the duty actually last? There is no expiry on the underlying duty, okay, to disclose. The seller's duty to disclose a known, dangerous, latent defect does not depend on when the incident happened. A basement that leaked and was fixed 10 years ago is still discoverable and still must be disclosed, and the seller needs to know that. And once a SPIS is given, it runs to closing, and it needs to be updated. If something happens from the time of signing to the time of closing, it has to be updated. The disclosure has to come forward. And it's important to know that post-closing, if something were to be discovered, let's say the buyer discovered a problem, the buyer has 2 years from that act of discovery to sue. So let's say it happened 5 months after closing at the next winter. Let's say it was purchased in summer, and then in the springtime, the next springtime, they had got a leaky basement, and they found out it was obviously an annual problem. Well, then they have 2 years from that discovery to sue. Okay, so it's not just 2 years from closing; it's 2 years from discovery. And so therefore, it's important to know that the disclosure obligations are ongoing duty to disclose. All right. And litigation deadlines are 3 separate deadlines. So don't collapse them into one. Now let's talk about the clauses that protect your buyer. There's obviously the home inspection clause. You can do specific water and foundation warranty clauses. There's the SPIS, if you can get the seller to sign one. You can request supporting documentation. You can ask for permits, invoices, contractor records, or anything such as that of any work done in the past. And you can also ask for a record of every verbal answer. So you could actually ask for a record of verbal answers, which means you could theoretically put questions to the seller and ask the seller to respond in kind to those questions. A lot of this you guys already know, not going to happen. Like, not many people will give a seller property information statement. I don't imagine any sellers are going to be willing to write verbal representations about the property. So it's really obviously you got to look at the ones you can ask for. Home inspection, clauses in your agreement of purchase and sale, and supporting documentation are always worthwhile. Another option is a post-closing holdback, but if you have no reason to request post-closing holdback, there's no problems you see, you didn't discover something before closing, it's very unlikely you're going to get that. So I want to talk about 2 clauses that you guys might see often. You have the standard clause, So the standard seller warranty clause. So obviously, seller warrants to the best of the seller's knowledge and belief that there has been no water penetration, seepage, leakage, flooding, or dampness in the basement, crawl space, or foundation of the property during the seller's ownership, except as disclosed in writing. So you see what this one gives is a basic representation. It's helpful evidence if the statement is false, but there's no express repair, credit, process, or post-closing survival. Under Austin, that clause right there, the previous case, the one that came out in January is Austin. Under Austin, that clause right there would not survive. Therefore, Austin would not have won if that clause was used in the agreement of purchase and sale. So you can't use that clause. And if you are using that clause, I invite you to up your game and choose a better clause. Now let's talk about a little bit better clause. So we have the more protective clause. Seller warrants to the best of the seller's knowledge and belief that during the seller's ownership, there has been no water penetration, seepage, leakage, flooding, or dampness in the basement, crawl space, or foundation of the property, and no structural damage, foundation cracking, or mold resulting from it, except as disclosed in writing. So you see those parts are almost the same. It's this extra clauses added. If discovered before closing, the seller shall promptly notify the buyer, provide reasonable access for an inspection, and give the buyer a credit for the reasonable repair cost. This warranty shall not merge on closing and shall survive for 2 years after closing. That is a much better clause, right? So you see here, it's still a warranty, but what it does is it's an ongoing pre-closing disclosure duty. There's the inspection, access, and repair credit remedy, and it's expressed that it's not going to merge on closing. So the standard clause gives a representation, where the protective clause gives a representation, a remedy, and survival rights. So if you want better protection for your clients, then draft survival language into your clauses, non-merger language. Otherwise, the clause will end at closing and it won't protect your buyer. Now, you guys know me so well that you know that I love to create clauses that are over and above. And so, first off, you just notice that those two clauses were warranties. And what did we learn about in the last webinar? In the last webinar, we discussed that a warranty cannot force the seller to do anything. With a warranty, the buyer has to complete the purchase of the property on closing, and then they have to, post-closing, sue the seller. Whereas if it is a condition of the agreement of purchase sale, the seller has to do something before closing because it is a condition of that deal that if they want to get it closed, they have to do something. So here's my clause, which I would love for you to see you guys use in the industry. It is a condition of this agreement of purchase and sale that to the best of the seller's knowledge and belief that there has been no water penetration, seepage, leakage, flooding, on and on and on, except as in writing. So that part is the same. It's just we went from the seller warrants to it is a condition. Make it a condition. And then we talk about if it's discovery before closing. So I broke it up into 3 sections, right? If at any time before closing it is discovered or the seller becomes aware that this condition is untrue, the seller shall promptly notify the buyer in writing. The seller agrees to provide the buyer and the buyer's contractor with reasonable access to the property on reasonable notice for the purpose of inspecting and determining the cost to repair the water penetration, seepage, leakage, flooding, dampness, or resulting damage. The seller agrees to provide the buyer on closing a credit against the purchase price in the reasonable cost of such repair as determined by a qualified contractor selected by the buyer acting reasonably. And this agreement shall be deemed amended accordingly. The transaction shall close on the completion date, notwithstanding such credit, unless the parties agree otherwise. So here, what we're saying is we're not going to delay the closing. Rather, what we're going to do is we're going to get a contractor in. First off, we're going to get the buyer access to the property. The buyer, because the thing about it, the buyer has an offer on the property, they have an vested interest in that property. So they have a vested interest to make sure that is corrected properly, an equitable interest to make sure that that property that they are buying is corrected properly to the state it was when they put an offer on it. So therefore, they get access to the property with their contractor to verify the extent of the damage, and then their contractor will provide forward an offer or an estimate as to what it's going to take to fix that. Then, rather than going through the process of having it fixed before closing, because a lot of times there's not time to get that done, but if there was time to get it done, great. The contractor should get in there and start working on it. But if they don't, and very often the sellers don't want a contractor in there working, well, then what it states is that the seller will give the buyer a credit on closing for that amount of money. Okay? And then we add in the survival. So this condition shall be deemed to have been fulfilled upon completion of the transaction, notwithstanding such fulfillment, and notwithstanding any other provision of this agreement per sale, including any entire agreement clause contained herein. This condition shall not merge on closing, but shall survive the completion of this transaction and continue in full force and effect for the benefit of the buyer for a period of 2 years following the date of closing. So once again, we know that the time limit is 2 years, so we've discovered it, so do it from 2 years to the date of closing. This non-merger then would protect the buyer. So if anything were to happen post-closing, then they had the ability to go back after the seller. This is what I would suggest you guys use. This is a much stronger set of clauses than obviously the first one and the second one, because both those were warranties, where this is a condition. It forces the seller to do something, but it also gives the buyer access, the ability to get a contract in there, get estimates, and get money on closing. And there's no fight about it, right? It's not like, oh, I'm going to fix it. Because you never want fix-it clauses. You never want to put a clause in your agreement per sale where the seller agrees to fix something. It never gets fixed the way the buyer wants. It's always better to just do a credit on closing. Hey, the seller is going to credit to the buyer $10,000. Done. You don't have to worry about if it's fixed properly, any concerns on closing. You know it's good. The deal's going to close. That buyer's going to get the $10,000, and then the buyer can get their contract to fix it the way they want. Now, the listing agent's duties to disclose. All right, under RECO Bulletin 7.4, the agent's obligation is tied directly to the seller's obligations. So if the seller has a legal duty to disclose a fact, and the fact is known to the listing agent must disclose the fact to every buyer who expresses interest in the property, make best efforts to get written acknowledgement from each one, and provide a copy of the acknowledgement back to the buyer. I understand getting an acknowledgement from the buyer is going to be really hard. But this is, like I said, this is RECO's position on this. My belief, let me talk about my belief in a second. Next, we have the Krawcheck. We have a case here, and the Court of Appeal in that case made the point plainly. An experienced agent who doesn't verify a seller's claim or push for an inspection when something doesn't add up can be held equally liable to the seller. So what that means then is if in the event that the listing agent doesn't verify these details, the listing agent could be equally liable if sued. And in the Krawcheck case, the listing agent was held 50-50 responsible with the seller. So in that case, it was a $100,000 claim, and the agent had to pay $50,000 of it, and the seller had to pay $50,000 of it, just because the agent didn't do their due diligence and have the hard conversation with their clients, their sellers, to find out what's exactly going on. Also, RECO Bulletin 7.3, material facts set the same 4 steps for every agent. Buyer side or seller side determine. So what you have to do is determine, disclose, advise, get an acknowledgement. That's what RECO says, best practice. Getting the acknowledgement is going to be the hard part, and also disclosing to every single interested person is going to be the hard part. What I suggest, probably as a best practice, is put the details in the Realtor comments section. Only the Realtor sees it, so put it on your MLS listing in the Realtor comment sections. Therefore, the buying Realtor will get the disclosure. Hey, if the buying Realtor misses it or decides not to disclose to their buying client, you've done your due diligence as the selling agent. You've done your job. Your duty is to disclose it. So as long as you put it in those Realtor comments, you've done your part, and therefore you've washed your hands of that duty to disclose, provided you get all the information from your selling client and disclose it there. Now, RECO's position, the duty comes from case law, not from TRESA, okay? So Bulletin 7.4 is explicit. A seller's disclosure obligation is a common law duty. It was determined by case law. It's not a rule created by TRESA, right? And when in doubt, disclose. Bulletin 7.3 tells agents to err toward disclosure, an explanation whenever there's genuine doubt about whether something is material. And if you always have a question, send the client to a lawyer, right? Especially me. I know a good lawyer. His name is Geoff Rabideau. Feel free to send the clients my way, and I'll answer the questions easily. As you guys all know, I don't charge to answer questions. That's not my. It takes me more to charge. It takes me actually. Let me explain this. It takes me longer to draft up an account to send to the client to get payment than it does to answer the questions. So I have no problem answering questions. It's just what I do. I'm always here for you guys, okay? And then the other side is document everything. In our profession, in your profession, we should be taking notes on everything, recording everything. Because if you ever do get pulled in front of RECO or get pulled into a court action, you want to be able to have your notes, right? Your notes are what's going to protect you. Not your memories, not what you say, but your notes is what is going to protect you. Okay, guys? So here's the practical playbook. If you're the listing agent, obviously discuss the SPIS with the client, see if they're going to sign it. Most of them won't sign it. Document every basement water conversation, even the casual ones. Disclose known material latent defects, and disclose them, I suggest, in the Realtor comments, and flag any pre-closing changes to the buyers, okay, or the buyers put an offer on the property. You do that, you have met your duties. Now, if you're the buying agent, get a home inspection, right, and or order any searches that are necessary. You can always request a SPIS. I don't imagine you're going to get one. Insert a very protective water foundation clause. I've given you two examples. One's a warranty and one's a condition. So I prefer the condition, of course, because it gives more protection. But if you're not comfortable with that one, go with the warranty. And advise your client on what they can expect about the 2-year limitation if in the event they were to discover something. So good practice on both sides of the deal is the same thing. Ask early, document always, and never guess, right? So here's the summary. Patent defects are the buyers to find. Latent and dangerous defects known to the seller must be disclosed. Active concealment is fraud. Even without intent to deceive, it is still fraud. It is the act of concealing that causes the fraud. The standard APS, the standard agreement per sale, doesn't contain the boilerplate clauses don't address water seepage and water infiltration. It doesn't address these situations. So use protective clauses as the buyer. Okay. If a SPIS is signed, then remember after, let's say, you're going to purchase and sale is signed, and if water was to come in, there's an active duty to disclose. Best to disclose and let the purchaser know about it. Okay. A buyer generally has 2 years from the date of discovery to sue, and the listing agent's duties track with seller's duties. So remember, you are jointly and severally liable as the listing agent. If the seller gets sued, you could potentially be 50-50 at fault. So don't let that happen. As always, I'm always here for you. Why I do these webinars is because I want to assist you in your jobs. I want to make you stronger realtors, winning realtors, so at the end of the day, you get the accolades that you deserve from your clients. If you have any questions, feel free to reach out. Otherwise, I'm Geoff Rabideau of Rabideau Law. Thank you very much for joining me today. You know how to find us. You have here our local telephone number, our toll-free number, email, website. And if you like this content, I'm doing all kinds of content like this, blogs, webinars, posts. Follow Rabideau Law on social media for more great content like this. And as always, your success is our mission. And here's to your next big win.